can you, oh, there we go. Who do we have here today? Let's see, we got Daniela, we have Christy, Lucy, I think, is on the phone, John, Aleda, Kristen, Anthony, and David. All right. All right, why don't I start then? When we are done, or when we've talked for a bit, can everybody see my the book here? David, can you see it on the screen?
I'm not seeing it on the screen.
No, it's not. It's not on the screen.
Is it? Okay, hold on. How about now? Is it on the screen now?
There we go.
Yes.
All right. What we're going to do when we go through this material is we're going to go through these questions at the end. And I think one thing I really wanted to do is go through these questions, and I'm going to ask each of you to answer one or two of them. But the answers are right behind, so it's not hard. So if you look at these questions here, and then you'll see the answers start. Actually, I guess that is the answers. Let's see.
I have page 158.
There we go. The answers start on page 158. Very good. All right, so let's go back. Okay, a court is competent. I'm at the bottom of page 125. A court is competent to adjudicate only if it has both personal and subject matter jurisdiction. In other words, the parties must be legitimately within the court's power, and the case must concern a controversy that is justiciable by the court. This next section here is kind of key. Personal jurisdiction in bankruptcy cases is not expressly addressed. However, it is well established that the reach of the code is nationwide, and the bankruptcy jurisdiction of the federal district courts extends to all persons who are present within the territorial boundaries of the United States. What this says is that you can serve anybody by mail. Hallelujah. How useful is that? So in bankruptcy court, you know, we are very favored with this luxury, is we don't have to hire process servers to chase people. That said, if you've got a recalcitrant debtor and the debtor's doing naughty stuff, and you want to get a TRO against him or her, you've got to personally serve them. So if you're seeking, and that would apply to anybody who you seek to enjoin from doing something, you have to personally serve. It's not enough to mail them a copy of the injunction. Any thoughts on that?
Sounds fair.
Okay. Let's see. Therefore, the usual jurisdictional concept of minimum context does not apply in a bankruptcy case. As long as the court has subject matter jurisdiction, a party to a proceeding or suit in a bankruptcy court cannot challenge jurisdiction on the basis that minimum contacts are lacking between the transaction or property at issue. So I'm trying to think from law school. What's the famous, what is it, international shoe? Isn't that the case that deals with minimum contacts and all that kind of analysis? Anyway, we don't get into that. So the Delaware, for example, here, Warren Beatty challenged the jurisdiction of the Delaware Bankruptcy Court. And the case Avery Tribune Company says the Delaware Bankruptcy Court had jurisdiction over him. Now, on occasion, in the bankruptcy court in the Central District of California, we run into situations where we have Vietnamese defendants. In which case then, and this is usually garment cases, then you've got to go to the Hague Convention, and now you're in trouble. And as a trustee, I usually think twice about getting involved in litigation like that, because then there's the enforceability of a judgment, etc. Has anybody on the Zoom had any experience with out of the country defendants? No. Aleda, have you?
Yeah, and then I just pray that they voluntarily file a proof of claim or something and we get them.
Or not? Okay. All right, so now we come to the heart of the matter today, and that's subject matter jurisdiction. The federal district courts are granted jurisdiction over 5 categories of proceeding by 28 U.S.C. Section 1334. This is our handy-dandy little diagram we were talking about last month, which we're going to talk about again. In the first 2, the jurisdiction is exclusive. That is, no other court may entertain proceedings in these categories. The second 3 confer non-exclusive jurisdiction of the district court so that some other court may also have the power to adjudicate these matters. Okay, so the district court has originally exclusive jurisdiction over the actual bankruptcy case itself. And that's what 1334A. Can everybody see that?
Yep.
This is a narrow category interpreted to include under the petition and its adjudication. No other court may hear and determine a bankruptcy petition. Under 1334E1, once a bankruptcy case has been filed, the district court has exclusive jurisdiction of the debtor's property at the commencement of the case, wherever situated, and also property of the estate. This provision brings the property under the control of the court upon commencement of the case, even though other courts previously had jurisdiction over it. So then we've got our little diagram here. So we've got the bankruptcy case itself and litigation of a property of the estate. The district court, and by extension, the bankruptcy court, has exclusive jurisdiction over that. Now, going to 1334E2, we really didn't touch on this last time, but over claims or cause of action that involve construction of Section 327. Can anybody tell me what 327 is?
Employment of professionals.
Right. So I guess the idea is that if you have some kind of dispute involving the employment of professionals, the bankruptcy court has exclusive jurisdiction over it, which would make sense. So that can't be adjudicated in state court. Okay. This is, I think, kind of important to remember. In Tennessee Student Assistance Court versus Hood, the U.S. Supreme Court described bankruptcy jurisdiction as principally in rem, as opposed to in persona. In rem, it is premised on the court's power over the estate array and the adjudication of rights concerning the assets of the estate. Most proceedings in the bankruptcy case either stem directly from this in rem jurisdiction or are closely related and ancillary to it. So when you're talking about jurisdiction, the essential question is always subject matter jurisdiction. The essential question is always going to be what is being litigated over, what is the prize? And that'll give you a clue as to jurisdiction. Okay, non-exclusive jurisdiction. 1334B gives the district court original but non-exclusive jurisdiction over 3 types of civil proceedings, which we're about to run through. So you've got here in B, you've got over civil proceedings arising under Title 11 or arising in Title 11 or related to cases under Title 11. And this is what we're going to be discussing today, as well as what's a core matter. Civil proceedings arising under Title 11. This category covers bankruptcy litigation other than the actual case itself. For a proceeding to arise under the code, it must involve adjudication of rights and obligations provided in the code, such as relief from stay under 362. In essence, the cause of action must be created by the code, or it must involve an issue that is so linked to the code that the issue either would not have arisen or would have been decided differently in the absence of the code. So let's just focus on this last sentence fragment. So the cause of action must be created by the code, or it must involve an issue that is so linked to the code that the issue either would not have arisen or would have arisen differently in the absence of the code. And in terms of interpreting that, we'll get to that in a minute when we go through our problem or questions. Okay, second, civil proceedings arising in a case under Title 11. This is an intermediate classification. Disputes that are intimately involved with the administration of the estate. Such as those concerning the allowance of claims or the approval of a loan to the estate would not come about outside of bankruptcy. So these are arising in a case. In Baker versus Simpson, which is right here, the court held that the Chapter 11 debtor's malpractice claim against an attorney relating to services rendered in the bankruptcy case arose in the case. It did not matter that the malpractice claim was governed by state law. So let's talk about that. Does that make sense? That the bankruptcy court would have jurisdiction, or the district court, because we're talking about the district court here, not the bankruptcy court. Bankruptcy court comes when we talk about core matters. Would that make sense that it would have ancillary jurisdiction, but not exclusive jurisdiction? I think, go ahead.
I thought it would be exclusive jurisdiction because it's a Chapter 11 professional matter.
I wonder, good point. I wonder if it belongs to the estate of the individual debtor, though. If it's the individual debtor, no. If it's the estate, yes, and it doesn't say. Sometimes a dispute arises in the case, even though it is tangential, it does not have an impact on the estate. I thought this is a good one. This is the H. Robbins case, which I guess is the mass tort case. The court held that a dispute between attorneys over the distribution of fees from a trust created under a Chapter 11 plan did arise in a bankruptcy case. Because the trust would never have existed in the absence of bankruptcy, this conclusion was reached even though it would have no impact on the estate. Because it's just attorneys arguing over money. Do you have a comment on that, Tinho?
I guess I don't know enough about that part. I thought that post-confirmation proceedings, the bankruptcy court typically retains jurisdiction unless the plan provides otherwise.
I think
So
so.
people contract around
Go
that.
ahead. Go ahead.
Yeah, but so people contract around that. So I just don't see how this would come up, at least now. I mean, maybe in the 90s, people were less careful with their plans being confirmed, but now I would not imagine that that would ever be a dispute because the plan would say the court retains jurisdiction.
Okay, assume it doesn't.
I think it could be a concurrent jurisdiction issue then.
Yeah, it says the court, see what you've got is you've got a trust of fees and all the attorneys are going to feed from it. And now there's a dispute as to who gets what. That has no impact on the estate, right?
There's no estate because it's post-confirmation, is
Right.
the way I see it.
Okay, fair enough. Civil proceedings related to a case under Title 11. Although these proceedings have a relationship to the bankruptcy case, they are furthest from its core. They involve litigation that has some relationship to the bankruptcy case, but arises out of rights and issues of non-bankruptcy law. Related litigation falls into one of two categories. The first and least problematical type of related matter is one that involves a cause of action that could have been brought by or against the debtor under non-bankruptcy law, but passed to the estate from the debtor or became a claim or by or against the estate. In this type of controversy, the estate is typically a party for the litigation, so there is no problem. Cases in this category concern litigation in which the estate is not involved, is between other parties, but the outcome of the litigation could have some impact on the estate. In these types of cases, a broad view of the relationship would enable one to trace some connection to the bankruptcy case. So then we skip down to the Pacor case. And it says, and going back to talking about taking the exam, if you were to hit this issue on an essay question, if you can name the case that is the seminal case of this issue, you've already gotten half credit. So if you can say Pacor, the grade is already going to give you half credit. The most influential formulation of the test is that enunciated in Pacor versus Higgins, Third Circuit case. A civil proceeding is related to the bankruptcy case only if its outcome could conceivably have any effect on the estate. If its disposition could alter the rights, liability, freedom of action, or options of, or have an impact on the handling or administration of the estate. And this test was approved by the Supreme Court in Celotech. Any thought on that? That's a pretty broad test, isn't it? What do you think, Mark?
I'm unfamiliar with that case. What are the facts on that, briefly?
I don't remember. We could look it up. Was it 743 F second 984?
Yeah.
Aren't computers great?
Well, I understand that ruling, but I'm having a hard time hooking it on to a set of facts that the ruling would apply to in my everyday practice. Just see.
Okay, this has to do with asbestos litigation. I guess as far as you're concerned with regards to your practice, the question is always, if you're on defense, is there a way to get this out of the hands of the bankruptcy court to
Yeah.
complicate things? So in terms of your practice, that's why you're learning about this.
Right.
All right, so where were we? Okay, I think this, beginning with this, the words, the appropriate scope, I think this is good, what the book is written. The appropriate scope of related jurisdiction where the case does not involve the state as a party should be confined to litigation that has a direct and demonstrable legal or economic impact on the estate so that affects the debtors or estate's freedom of action, the administration of the estate, or the distribution to creditors. In each of these cases, the court found no related to jurisdiction over dispute between third parties relating to an asset sold by the estate. There was insufficient nexus between the litigation and bankruptcy cases. So this is the classic example, is the estate sells a house and then there's a dispute over the asset. In that case, the parties have to go to state court. Any thoughts, questions? Says, by contrast, in farmland industries, the court found that third-party litigation relating to the implementation of a confirmed chapter 11 plan did fall within the court's related to jurisdiction because there was a definite and non-speculative prospect that the estate could be liable. But as Tinho pointed out, I mean, a lot of this goes to what jurisdiction has been retained post-confirmation.
I'd also say related to jurisdiction because it's so broadly defined. People will try to use that as a hook to remove anything to bankruptcy court. And it's kind of a crapshoot whether or not the bankruptcy judge retains it.
Yeah, it depends on the judge itself. Okay, at this point, why don't we do some questions and then we'll go back and talk about core, non-core. Okay, Julie Dixon resides in State A, where she owns and operates a retail store. Her business has done poorly over the last couple of years, and she's fallen behind on her payments to creditors. Her credit has been cut off, and she does not have the cash to buy any more inventory. A number of Julie's creditors have decided to file a petition to place her in involuntary bankruptcy. That's kind of sad, huh? Each of the controversies described below has arisen or will arise either in connection with the bankruptcy case itself or in relation to Julie's affairs. Consider whether or not federal district court in state A has jurisdiction over the terms of 28 U.S.C. section 1334A, B, or D. So now what we're talking about here is the district court, not the bankruptcy court. Okay, Mark, do you want to start with A? Does the court have jurisdiction to hear the petition and to grant an order adjudicating Julie bankrupt?
I'd say yes, but I came in the middle of the jurisdiction discussion. Involuntary, right?
Yep. Okay, so the solution says the petition, the consequent hearing, and the order for relief are the case under Title 11, i.e. the bankruptcy case over which the court has exclusive jurisdiction under 1334. So the answer is yes. Okay, Tin-Ho, you get the next one, B.
I'm reading it. I think this is tricky because I don't deal with involuntaries too much, but I understand that until the order for relief is entered, there's no automatic stay. So it's a state court issue until the order for relief is entered in the involuntary. That's...
What a great response. Very good. All right, so let's assume an order. Let's assume an order for relief. Yeah. A plus. Okay, so assume an order for relief has been entered. Go ahead and answer the question.
So the district court or the bankruptcy court has core jurisdiction over the automatic stay. So yes, it does.
All right. So they have exclusive jurisdiction, correct?
Yes.
Okay, so we go to C. Christy.
A few weeks before the petition was filed, Julie, realizing that she was insolvent and that creditors would soon take action to collect their debts, repaid to her brother an unsecured loan of $5,000. Although the loan was not yet repayable, Julie was concerned that if she did not repay it immediately, her other creditors would pounce on her assets and leave her insufficient funds to settle her brother's loan. This preferential transfer is avoidable by Julie's trustee under 547. Does the court have jurisdiction of the trustee's avoidance suit against Julie's brother? I would say.
I'm gonna go ahead, but I'm gonna pull up the answer. But go ahead.
Okay. I'll see the answer. No, I think I would say that yes, the trustee has a right to avoid it. And I would say it would be exclusive, but if not, it's at least not exclusive of it has to do with the bankruptcy. It's a core issue, it seems to me. Fix.
Okay, so it says here, can everybody see the answer on the screen? The trustee's right to avoid the transfer owes its existence to 547. However, the avoidance suit will likely implicate rights created by non-bankruptcy law.
Okay.
Therefore, even though the suit does arise under the code, the presence of non-bankruptcy issues may place it in the category of related proceedings. This makes no difference to the applicability of 1334B, which covers both categories. However, it does have an impact on bankruptcy court jurisdiction under 157, which we're going to talk about next. So we're doing the district court, then we're going to go back through and talk about bankruptcy court. But in any event, the district court could hear this.
Yeah.
Okay, David, do you want to try D?
Prior to bankruptcy, Julie bought some inventory from a supplier. Inventory was delivered. Julie protested that was defective and demanded a price reduction. Supplier refused at the time of the bankruptcy. Dispute had not been resolved. Supplier has proved a claim for the sale price of goods. Trustee objected. Yeah, district court would have the jurisdiction over the claims allowance process. I think there'd probably be some state law issues in there, but that shouldn't matter for the jurisdiction.
I can just see a bankruptcy judge trying to get rid of this. Let's see. The dispute in this question involves issues of state law, the rights of a seller and buyer under UCC Article 2. Had Julie not become bankrupt, the case would have been resolved in state court. However, as she is bankrupt, the seller must claim against her estate, and this trustee succeeds to her defense. The outcome of the case will have an impact on the estate because it will affect the size of the seller's claim against the estate. Although the claim and objection procedure provided by the code, the substantive rights do not arise under the code, while they are related to the bankruptcy case. Such related proceedings also fall within the court's jurisdiction under 1334B. As in question C, it makes no difference for the purpose of the district court jurisdiction whether the litigation arises under the code or related to the case. However, this difference is significant with regards to the bankruptcy court's jurisdiction over them. So this, I think, would be an example of something that would be remanded. Where the impact on the, in the case of the bankruptcy court, where the impact on the estate is clear as this, the related litigation actually involves the estate and the outcome binds it. There is no difficulty in seeing that the litigation is related to the bankruptcy case. However, matters are considerably more difficult where the impact of the proceeding is less direct and obvious, as in our next questions. Okay, Jordan, can you do E?
E. A few months before bankruptcy, Julie obtained a loan from a finance company because the finance company was concerned about her credit and insisted that she find a surety to guarantee her debt. Julie's sister undertook the suretyship obligation. When Julie became bankrupt, the finance company decided to sue the surety for payment of the debt. Does the court have jurisdiction to deal with the suit between the finance company and the surety? I would.
Let's scroll down and let's see what the book says. Okay, Jordan, go ahead.
Well, I didn't read the answer, but it
Well,
would
here
seem
it
to
is.
me
Here's
that
the
this
answer
is
right there.
state court issues.
Says, like the sales dispute in question D, the suit between the finance company and surety involves issues of state law that exist in the absence of bankruptcy and would normally be resolved by a state court. Therefore, the suit against the surety certainly does not arise under the code. The question is whether the suit is related to the bankruptcy case so the court has jurisdiction over it. The fact that the estate is not a party to the suit is a strong indicator that the suit is not related to the bankruptcy case. However, this is not conclusive. Even though the debtor is not a party, a suit between outsiders can have enough connection with an impact on the estate to be related. Where the litigation does not involve the estate directly, the widely accepted test enunciated in PAYCOR, which we talked about, and approved in general terms by the Supreme Court, is that the outcome of the proceeding must have some conceivable effect on the bankruptcy case, altering the rights, liability, freedom of action, or options of the debtor. If the finance company wins the suit as paid by the surety, the impact on the estate is a substitution of creditors. The finance company falls away as a creditor, and the surety, who has a right against recourse against it, becomes a creditor. If this happens, there's no impact on the estate. The liabilities are unaltered. However, the litigation between the surety and finance company could do more than simply determine the identity of the creditor. They could also determine the validity of the debt or fix the amount of the claim. If so, the impact on the estate could be significant. Therefore, if the extent and validity of the debt is an issue in the case, the litigation would satisfy the term of relatedness. Its income would have a measurable and preclusive effect on the estate's ability to assure surety. In re Brentanos, the court found that an action between a creditor and a surety had enough of a relationship to the bankruptcy case to fall within the court's jurisdiction. Are any of you old enough to remember Brentanos, the bookstore?
Yeah.
That was a long time ago. All right, let's see. What are we on? F? Okay, who do we got here? Who else we have? John, you want to try F? I don't know if John's, yeah, John's there.
Yeah, but I haven't really been,
Tell you what,
Paying attention.
just read the question and we'll take it from there.
sure. About 3 months before Julie's bankruptcy, she hired a contractor to perform some repairs to her shop. Julie paid the contractor in full for the work. After the project was completed, a subcontractor who worked on the project sued the contractor for the price of its work. The contractor is defending the suit on the grounds that the subcontractor's performance was unsatisfactory and had to be redone. Does the court have jurisdiction over this suit?
Chin-Ho, what do you think?
Who owns the shop? Is there a lien right? I mean, I think there's some things missing. So under certain facts, it could be affecting the estate to the extent that the shop is part of the estate. It says her shop. So otherwise, it doesn't affect the estate. It's related to at
Go ahead.
most, but only if there's an outcome that actually affects the estate will the district court have jurisdiction.
What they're saying here, I've got it up on the screen, is that the only conceivable impact on the estate of this litigation between the contractor and subcontractor is that if the contractor is held liable to pay the subcontractor and does not pay, the subcontractor may be entitled to put a mechanics lien on the property. However, it's not clear the subcontractor has complied with the statutory requirements for a mechanics lien. Even if he has, the automatic stay would stop it. Therefore, the given facts do not provide enough information to determine whether this third-party dispute is sufficiently connected to the case to qualify as a related proceeding for the district court. Okay, Daniela, can you do the last one?
Well, then aren't there two more?
I think, well, we're going to have another set. You're
Okay.
right, there are two more. Okay, G.
G, okay. Shortly before bankruptcy, Julie had sold goods to a buyer who resides in state X, located some 2,000 miles from state A. The transaction was conducted through the mail, and the buyer has never set foot in state A. Although payment for the goods was due on receipt, the buyer has not paid for the goods. Does the court have jurisdiction to deal with the trustee's suit against the buyer for payment? And I would say yes, but let's see. The buyer is the debtor's debtor. He resides in state X, remote from state A, in which the court sits. In addition, many essential elements of the transaction occurred in state X. Nevertheless, the court's jurisdiction to hear the action for the price of the goods is not dependent upon the defendant's presence in state A, nor on the concept of minimum contacts. Instead, it arises out of 1334B, and the court has jurisdiction over this action for payment because it arises in or is it related to the bankruptcy case?
I'm looking at the answer. In this case, the trustees are party to a suit and acting pursuant to a duty to collect estate property. It's not a court proceeding. The substantive essential right that's being enforced here is the debtor's right to payment under a contract for the sale of goods. This right is not conferred by the code, but by state law, even if it's enforcement taken for the benefit. It is a related non-court proceeding. Northern Pipeline, the court found a contract suit to be beyond the bankruptcy court's jurisdiction. Okay, my understanding is that if a bankruptcy trustee wants to sue on accounts receivable, she does so in state court. Any thoughts on that?
Well, some people think that you can do a turnover action in bankruptcy court for liquidated debts owed. So sometimes I see people sue on a turnover adversary for for recovery of accounts receivable. I don't like it.
I haven't seen that. The thing is, you need an adversary proceeding, right?
Yeah, an adversary against a third party, but because they want the bankruptcy judge who's more inclined to just give the trustee something because, you know, judges love trustees. Sometimes you see that. And, you know, I don't want to go to state court. So I understand the allure.
I would obviously get special counsel to do this. I wouldn't get a bankruptcy attorney to do this. But I can tell you the instances where I am given accounts receivable that are collectible arises maybe once every 5 years. Aleda, do you have a different experience than that? How often do you see collectible accounts receivable? I think you're on mute.
No, I don't deal with those issues.
No, it just doesn't arise. Okay, back we go. Okay, let's see. Anthony, have I called on you?
No, not yet.
Go ahead.
Okay. A year or so before her bankruptcy, Julie bought a computer on credit. The seller retained a security interest in it to secure the unpaid balance of the price. The security interest is valid and unavoidable, and the debt to the seller exceeds the value of the computer. The trustee therefore abandoned it under Section 554 so that the seller could foreclose on it. As discussed in Section 12.4, Section 554 permits the trustee to abandon a state of property if the debtor has no equity in it and the property is of no value to the estate. After recovering the computer, the seller refurbished it and fraudulently sold it as new. Upon discovering this, the buyer demanded cancellation of the sale and return of the price. Does the court have jurisdiction over the suit between the buyer and the seller? Well, at some point it had jurisdiction over the computer, but now that it's abandoned, seems like the buyer's concerns are not related to this bankruptcy case.
Right, so this is not related to the bankruptcy case. Any questions? Okay, so now what we're going to do is we're going to go back and go through this analysis again. First of all, we'll look at the text, not as to the district court, but as to the bankruptcy court. So I am going to page 134. Okay, the grant diagram 7B, which is here. Let's see. Presents the way in which the bankruptcy court jurisdiction is channeled through the bankruptcy court. So the district court has jurisdiction over through 1334, and then it refers the cases to the bankruptcy court. Now, two statutes you have to look at are 151. Can everybody see this? Everybody see 151?
Yep.
In each judicial district, the bankruptcy judges in regular service shall constitute a unit of the district court to be known as the bankruptcy court. Each bankruptcy judge as a judicial officer of the district court may exercise the authority conferred under this chapter with respect to any action, suit, or proceeding and preside alone and hold a regular or special session of the code, except as otherwise provided by law. So this authorizes bankruptcy courts to exist. And then you go to 157A, which says that each district court may provide that any and all cases under Title 11 and any all proceedings arising under Title 11 or arising in or related to under Title 11 shall be referred to the bankruptcy judges. All right, so we got that out of the way. So then you've got the bankruptcy case, you've got court proceedings, and you've got related proceedings. With regards to the bankruptcy case and court proceedings, the bankruptcy court may make a final determination. With regards to related proceedings, it can make a recommendation to the district court. In which case, then the district court makes the final decision. Okay, so let's see. Under 157D, the district court retains ultimate control over the bankruptcy court if for cause shown either on its own motion or the motion of a party. It may withdraw any case or portion of the case from the bankruptcy court. Now, something I wanted to point out and talk about. I'm looking at 157D. The district court may withdraw in whole or part any case or proceeding referred to under this section. If it requires consideration of both Title 11 and other laws in the United States regarding organizations or activities affecting interstate commerce. Do you, at least in our district, we've had common carriers filing bankruptcy. Does anybody, in other words, trucking companies, which are regulated by federal law, how would that impact the bankruptcy court? Anybody have an opinion on that? Or an airline, let's say an airline filed bankruptcy. How do you think this statute would affect the bankruptcy court?
So does that make withdrawal of the reference mandatory for these common carriers upon motion of a party? And
That's
then
that's my
and
question.
then,
That's my
and then
question.
and then the district judge is like, I have no idea what to do.
Well, they remand it probably for, to make findings.
Yeah, that sounds like a mess.
Anybody have any thoughts on this?
I think the reference probably to other laws just limits to the interpretation of the interstate commerce type of legislation rather than the specific entity involved.
David, do you have trucking companies go bankrupt?
Quite a bit. We've got a lot of logistics around here.
Yeah? Does this ever come up or no? No one ever raises this?
No, it never has.
All right. Okay, final adjudication. The final disposition of bankruptcy litigation depends on the nature of the rights in issue. Because bankruptcy judges do not have Article 3 status, the bankruptcy court cannot finally adjudicate all matters brought before it. It is empowered to make a final judgment or order in matters called court proceedings. Under Northern Pipeline, Congress may provide for determination of the rights by a non-tenured judge because these rights were created by Congress or inextricably linked to a regulatory scheme, that is, the restructuring of debtor-creditor relationships with bankruptcy set up by Congress. However, the bankruptcy court may not render a final judgment in matters that are merely related to the bankruptcy, but require the resolution of non-bankruptcy rights. So what we're going to get into here are private rights versus public rights. A private right is when someone hits your car and you have the right to sue them. Public rights are when you have a claim against the federal government or there's some kind of right created by Congress. And I brought this up here. I think you can see this at the moment. But this goes through public rights versus private rights, which is at the end of the day what you're getting to in core versus non-core. I would like to say that with regards to testing purposes, you do not have to get too deep into the weeds here, other than be able to issue spot, all right, and talk intelligently about whether the bankruptcy court would have jurisdiction over this. Okay, I'm moving to the bottom of page 136. It says section 157B allows the bankruptcy court to hear, determine, and enter orders in all cases under Title 11 and all court proceedings arising under Title 11 or arising in a case under Title 11. This means that the general referral by the district court enables the bankruptcy court to hear and decide the bankruptcy case as well as court proceedings. A court proceeding under 157 corresponds to proceedings arising under or arising in a case under the code over which bankruptcy jurisdiction is conferred to the district court by 1334B. In Stern versus Marshall, the Supreme Court made it clear that court proceedings encompass only proceedings arising under the code in a case under the code. If a proceeding does not fit one of those two categories, it is non-core and hence related to the case. The court proceeding has been defined as one that invokes a substantive right provided by Title 11 that by its nature could not arise only in the context of a bankruptcy case. This test was enunciated in Wood. So let's go down to here. I'm at Waldron versus Stone in the middle of the page. The debtor in possession disputed a creditor's claim on the grounds that the claim was based on fraud. The bankruptcy court found that the creditor had committed an egregious fraud on the debtor prior to the bankruptcy and therefore disallowed the claim. In addition, it awarded compensatory and punitive damages to the debtor. The Court of Appeals held the bankruptcy court had jurisdiction to allow the claim. Although the fraud defense to the claim was based on state law, it arose under the bankruptcy statute because it was inextricably linked to the claims allowance process. However, even though the award of damages was based on the same facts as the claim allowance, the damages award was not part of the process. It would require the proof of additional facts beyond the process. It was therefore not core, but related, and required final determination of the district court. So even though, if you look at 157, and it says that it says counterclaims by the state 157B2C. Here, because this is based on non-bankruptcy law, it is non-core. And where the court overreached is when it was allowing punitive damages. And I think everybody on the Zoom call would be uneasy when the bankruptcy court is issuing that. And I think that would go through all of your minds that, hey, the court might not have jurisdiction to do this. Any thoughts? Tinho?
If I'm seeking punitive damages, of course the bankruptcy court has jurisdiction to issue that. I've gotten punitive damages from the bankruptcy court before. And then they settled, so it never came up.
From memory, there was some issue about punitive damages and the authority, notwithstanding what we're talking about right here. There is some body of law that says the bankruptcy court doesn't have authority to do that.
What about punitive damages arising under a court proceeding such as violation of the automatic stay or a discharge?
Well, there it is provided for. But I think here where you're talking about a dispute, creditor dispute, I don't think the bankruptcy court has jurisdiction. And so the court so found, but I think that is the general rule. Just because a bankruptcy judge gives you something doesn't mean it's going to be upheld on appeal. Let's see. Moving on. Okay, coming down to here, the Granfin Sarah case. Section 157, I'm on the bottom of page 138. Section 157B2 sets out a non-definitive list of core proceedings. The list is a guide, but it's not entirely reliable. Litigation is only a core proceeding if it satisfies the test above. Congress cannot simply declare something to be a core proceeding and confer jurisdiction on the bankruptcy court over it. If a matter does not qualify as a core proceeding, its designation in 157B2 is wrong, and the provision could be struck down as unconstitutional. So this is the Granfin and Sierra case. So what Granfin Sierra says is just because 157B2 says it doesn't make it so. So even though Congress has laid these things out as core matters that the bankruptcy court can hear as a core proceeding, that doesn't necessarily make it so. And instead, you have to go to Stern v. Marshall. which was a bankruptcy case with Judge Bufford in our district. A 5-justice majority concluded that the statutory classification of 157B2 was unconstitutional. The case involved litigation between the estates of the debtor, Vicki Lynn Marshall, better known as Anna Nicole Smith, and Pierce Marshall, the son of her late husband, over the debtor's rights to the late husband's multi-million-dollar estate. Pierce had filed a claim in Vicki's bankruptcy case, contending that Vicki had defamed him. Vicki counterclaimed, alleging that Pierce had tortiously interfered with her rights to acquire half of her late husband's property. The issue before the Supreme Court was whether the counterclaim was a court proceeding. The counterclaim clearly involved a matter of state law, but 157B2C includes as court proceedings counterclaims by the estate against persons filing claims against the estate. Although the majority recognized that the counterclaim in this case fell within the statutory definition of a court proceeding, it could not be so treated under the Constitution. The counterclaim was unquestionably a suit at common law. It did not involve a claim that was created by the code, and it did not involve adjudication of the same issues that had to be resolved in deciding whether or not to allow Pierce's claim. It was therefore not a matter of public right, closely intertwined with a federal regulatory scheme. Rather, it was a related matter over which the bankruptcy court did not have power to make a final determination. Any thoughts on that? So the problem is, because the counterclaim was on a different legal theory based on non-bankruptcy law, it made it non-core. Okay, why don't we now turn to the questions? And it's the same questions, and we're going to go through the questions again, but we're talking about bankruptcy court jurisdiction as opposed to district court. Okay, decide whether the controversies described in example 1 are core or non-core proceedings. In answer to the question, consider the general guidelines identified in section 735. For convenience, the proceedings are referred to here. Okay, Aleda, the bankruptcy petition. Can the bankruptcy court hear the bankruptcy petition?
Yes.
The bankruptcy petition is the case under Title 11. It may be heard and finally disposed of by the bankruptcy court. Okay. Let's see, David B. The secured party's application for relief from stay.
Yeah, that's a court proceeding. There's really nowhere else stay relief could come up except in the bankruptcy context.
Okay, let's see, Tinho C. See, this is a long answer. This is why I gave it to you. Are you there, Tinho? You're still online.
I was muted.
Oh, I'm sorry.
My bad.
Okay, C.
All right, so
This is the trustee suit to avoid a preferential transfer. Is that a court proceeding?
yes.
Sort of.
Yeah, sort of, because didn't this come up in one of the prior questions? I'm just
Right.
scrolling down to that part of it.
I've got it on the screen, the answer.
Okay. Yes, a preference arises under the code, but because it implicates state law issues, some aspects of it may not be core.
Says, however, the avoidance power is also tied up with the rights of the transferee under non-bankruptcy law, and litigation concerning the avoidance of a preferential transfer involves adjudication of private rights. So once you're into private rights, that takes it out of core. So once again, the reason why we're talking about this is because a bankruptcy judge is an Article I judge. and Article 1 judge does not have the inherent authority to adjudicate private rights. The issue was raised by the Supreme Court in relation to the fraudulent transfer in Grenfin Sierra. The court was not directly concerned with the legitimacy of 157(2). The focus of the case was whether the defendant was entitled to a jury trial and a trustee suit to avoid a fraudulent transfer. Although H treats the avoidance of a fraudulent transfer as a court proceeding, and although the trustee was asserting the avoidance powers provided by 548, the court characterized the avoidance suit as a matter of private right, a quintessential common law suit, clearly with the protection of Article 3. Realize since the statute of Elizabeth in the 1500s, fraudulent transfer laws existed and exists under California law. I mean, outside of bankruptcy law. Should the same analysis apply to a suit to avoid a preferential transfer? There's an important difference between suits to avoid fraudulent transfers, which have been available to creditors outside of bankruptcy for centuries, and suits to avoid preferential transfers, which are an inherent bankruptcy remedy. This would suggest that although Congress erred in including suits to avoid fraudulent transfers in 157(b)(2), it was correct in including suits to avoid, it was correct in characterizing preference avoidance suits as being core. The case Langenkamp versus Culp, which is another case you need to know for the final exam or for the specialty exam, make it clear that a suit to avoid a preference is a legal claim which would give rise to a jury trial. However, characterizing it as legal rather than equitable is not tantamount to saying that it is necessarily non-core. Although many core proceedings are equitable, it is possible to have a core proceeding that is legal in nature. Therefore, the determination of whether the suit falls within the core of bankruptcy has to be decided on public rights analysis expanded by the Supreme Court. It is not clear how a preference suit should be classified. So that's always a question mark. Okay, let's see. Aledi, do you want to do D?
The seller's claim for the price of the goods is a claim against the estate. Clearly, the resolution of the dispute relating to the sale of goods must be resolved under state law, which under some circumstances would make this a contract of the kind held to be outside bankruptcy court jurisdiction. In Northern Pipeline, however, the seller has provided a claim in the estate, and the trustee's assertion that the goods were defective is raised in the course of the claim allowance process.
So the fact that the claim or that the buyer, let's see, the seller's claim for the price of goods is a claim. The seller's filed a proof of claim is critical here, because that gives the court jurisdiction, bankruptcy court jurisdiction. Go ahead.
The allowance or disallowance of claims is part of the bankruptcy process and listed as a court proceeding in 157(b)(2)(d). Of course, as stated before, the mere fact that 157 lists a matter as a court proceeding does not make it so if Congress did not have the power under the Constitution to confer jurisdiction over the matter on the bankruptcy court. However, in Stern versus Marshall, the Supreme Court indicated that Congress did not mischaracterize the claim allowance or disallowance process as a court proceeding. Therefore, provided that resolution of the trustee's dispute is part of the process of claim allowance or disallowance, and it involves the same transaction and factual issues as a claim, the trustee's claim becomes integral to the restructuring of the debtor-creditor claim relationship and fits within the bankruptcy court's core jurisdiction.
Right, so long as you don't start asserting punitive damages and things like that, this is core and the bankruptcy court can hear it. Okay, Mark, a creditor's suit against a debtor's surety, what would be would that be core or non-core?
I'm sorry, could you, I'm struggling with the screen. Could you repeat that?
Okay, a creditor's, the question's on page 157, and then the answer is on page 160. But the question is a creditor's suit against a debtor's surety. Is that, would the bankruptcy court be able to hear that as a core matter?
I don't believe so. And it doesn't sound like a claim arising out of a specific bankruptcy code section. And its effect on the bankruptcy doesn't seem to be significant.
You are correct. It says here that the suit against the surety was treated as falling within the district court's jurisdiction. That isn't, but it's not a court proceeding because it does not involve the enforcement of any right conferred by the code. Even though the bankruptcy court may hear the action and make a determination, it has to give proposed findings to the district court. So you are correct. Daniela, F.
F is creditor's suit against a debtor. Oh, no. Oh, sorry. The suit between the subcontractor and the contractor relating to work on Julie's shop.
Correct.
Hmm.
So would that be core or non-core?
I would say non-core.
Right.
At,
Yes.
let's see.
Go ahead.
At best, this would be, okay. At best, this would be no more than a related proceeding. However, as explanation 1F indicates, the connection to the bankruptcy case may be too remote for the suit to be treated as related at all.
Christy, can you do G?
Yes, but I don't have the question in front of me.
The trustee's suit against the buyer of goods from the debtor who has not paid for the goods.
Okay, so I would say that that it's not a not core proceeding. Unless the debtor's right to the sale of goods arises under the bankruptcy code, which I don't think it does.
Right, so this would not be something the bankruptcy court could finally determine. Let's see, David H, which is a suit between the buyer and the seller of the computer abandoned by the estate.
I think that's the easy one. No jurisdiction at all. So nothing for the bankruptcy court to do.
Okay, that's it. Does anybody have a question over our class today?
Oh, I thought we might talk about sovereign immunity because
Go ahead.
that was part of the chapter. But I just want to say Judge Clarkson is going to publish, he has posted, he's going to publish a decision on the waiver of sovereign immunity by the IRS because the IRS argued, Judge Clarkson, you have no jurisdiction or you can't sanction us because we have sovereign immunity. And so he's publishing a decision on why that's not true.
Well, that'll be good. Okay.
Do you have information about what case it is?
Yes, it's in the Egan Avenatti bankruptcy case in one of the adversaries. I can give you a case number.
Yeah, please.
You want to see
ahead.
the IRS? So it's currently posted. The adversary is 820 AP 1059.
Okay.
And it's already posted, so it'll be published, but you can find it on the Central District Court site.
Okay, thanks.
All right. Does everybody have their calendars out?
Yeah.
How does June 14th or June 21st look?
I'm good.
Either of those work for me.
That works.
Everybody's okay? Okay. We will have our next class on chapter 5 on noon on June 14th. Enjoy your weekend. Thank you.
Thank you. Thank you for the class.
Bye-bye.
Thank you.
Bye-bye.
Thank you.